Welcome back to another episode of Subro Sessions. I'm Ryan Bennett, an associate in the subrogation department at White and Williams. I'm joined today by partner Ron Pingitore. Ron has been with the firm for over 25 years and has a wealth of experience in today's topic, pursuing a spread theory. For the purposes of this podcast, we will focus on 1, pursuing a spread theory and how it relates to subrogation. 2, how to tailor your investigation when pursuing a spread theory. And finally, we'll provide a few examples of a spread theory scenario.
All right. Thank you, Ryan. I'm happy to be here. This is my first foray into the podcast world. I'm sure we'll have some fun. As you know, pursuing a spread theory in the context of your subrogation investigation still begins with the initial origin and cause determination. Like any loss, you still need to try to nail down what caused the fire and where the fire originated. And in this scenario, we're going to be talking primarily about fires, which is the context of most spread theories. Now, the spread theory, in my mind, gives you a second bite at the apple for recovery purposes. Your focus is on a secondary act or omission, and it's one that exacerbated the initial loss in terms of damages. So even if there isn't a viable subrogation opportunity arising out of the initial loss, you may be able to build a recovery opportunity around a secondary act or omission. And then more specifically, you want to examine the loss to determine if the damages were made worse by a lack of preventative measures or design considerations or other considerations intended to contain the initial loss. Now, again, the spread theory typically applies to fire losses, but it can certainly go beyond fire losses. And we have experience with water losses and spread theories as well. Now, maybe to look at a few examples of spread theories that I've been exposed to are the following. Delayed reporting by the alarm company. This can provide you with a spread theory against another party that wasn't necessarily involved with the initial event, but because there was some delay with reporting of the fire, you have a secondary theory. And it typically is an alarm company that doesn't report the fire to the fire department, or they're delayed in reporting it to the fire department. Another scenario that I've been involved with is fire-rated doors in a building being propped open so that the fire is allowed to spread from one building to another. There are also scenarios involving defects with the fire suppression system, where it either doesn't activate or is delayed in activation. And likewise, there are spread theories involving design deficiencies with firewalls, with fire ratings, and fire separations in buildings. So they come in a variety of packages, but all of them focus on the fact that damages from an initial loss, regardless of its cause, were exacerbated by some secondary act or omission.
That's very interesting. And the first question I have would be, does the way you investigate the loss change if you know that you're going to be pursuing a specific party based on a spread theory?
It does. It becomes a little bit more complicated because in addition to, again, determining the cause and the origin of the first loss, and then identifying a secondary factor or event that exacerbated the damages resulting from that loss, you now need to be able to put yourself in a position to quantify or articulate the damages, and specifically the damages attributed to that secondary event or that secondary factor. So now you really have three focuses with your investigation. You're looking at the initial origin and cause. You're looking at the secondary factor or event that exacerbated the damages. And then you're also looking to be able to quantify the spread of the fire in terms of damages. And sometimes it's clearer than others. If, for example, you have a fire-rated door, going back to an earlier example, that was missing, that was compromised or propped open, the recovery position for subrogation purposes would be that the fire would have been contained to the room of origin, but for the fact that the fire door was either propped open or otherwise defeated. So in that situation, you're able to articulate the secondary fact or event, which is the defeating of the fire door, and you're also able to articulate and quantify your damages, which is anything outside of the room of origin. That's a simple set of facts. It's certainly one that I've dealt with before. but you're able to build on the fact that a fire-rated door, which is typically made of steel or a solid core, has a demonstrated ability to prevent the spread of fire for a specific period of time. Oftentimes it's 2 hours. So under those set of facts, you can build on your recovery theory, the demonstrated ability of the door to prevent the spread of the fire, and that can be kind of your first block in the foundation of building the theory involving the spread of the fire itself.
That seems like it's a lot to consider for just a routine investigation.
It is. It's definitely a lot to consider. And keep in mind that you're also typically building on a second set of experts. You have your first expert, which is typically your fire investigator, determining the origin and cause, and you're leaning on the fire investigator for that purpose. But now you're going to a secondary event, and that might involve a second discipline of experts that you need to secure and to make sure that they have the facts necessary to underpin their findings. And then, of course, going back to the damages, you have a third typically set of proofs, which oftentimes involves an expert, and that's differentiating or extinguishing your damages between the two losses.
So that would be even more to consider when pursuing a spread theory.
That's right. But with any loss, you really need to be thinking spread theory as a starting point, regardless of the initial cause and origin, because you don't know where the facts are going to take you. So everyday due diligence so that you make sure all potential avenues of recovery are looked into includes considering spread theory as the result of a secondary act or omission.
I think that's very helpful, and you certainly have a lot of experience in pursuing these. And now that we provided an overview of the spread theory, I think it'd be helpful to take the listeners through an example or two that we've encountered as subrogation attorneys. You've already mentioned one or two, but it might be helpful to go through another. So in this instance, or in this hypothetical, there's a fire that originates in a restaurant's kitchen while the cooks were preparing food on the stove. It appears that the fire was caused by a buildup of grease and food debris on the stove itself. The kitchen wasn't very clean. However, when the fire became fully involved, the fire suppression system did not activate, meaning the nozzles above the stove did not disperse a chemical agent onto the fire to extinguish it. The fire spread throughout the restaurant and it burned down the entire building. During the initial investigation, you learned that the suppression system was inspected a week prior to the fire and received a, quote, passing checklist.
Yeah, you've described a very typical scenario that we've often investigated and pursued for recovery purposes. There's a little bit to unpack with this one. On your hypothetical, initially you determined that the fire was caused by the buildup of grease and overall lack of cleanliness in the kitchen. And under that set of facts, the restaurant may potentially be at fault for causing the stovetop fire. If the restaurant is your client's insured or you're insured, that certainly presents a problem for subrogation purposes. However, if the suppression system inspection company shares fault and it can be proven that they created a defect or failed to identify a defect that prevented the system from containing and suppressing the fire, then you have the starting point for a spread theory against the inspection company. So we're not now looking at the damages that resulted from the stovetop fire. We're looking to recover the damages attributable to the fact that the suppression system didn't operate and function as intended and allowed the stovetop fire to spread beyond the stovetop and to damage the entire building itself. Now, within that hypothetical, you need to figure out why the system didn't activate and attribute it to the inspection company. So, for example, if the inspection company failed to reinstall the actuator cartridge, that could explain why the suppression system didn't operate. And now you have a defect with the inspection company's work that allows you to pursue that spread theory. And this is a secondary act or omission that supports the spread theory, that being the damages beyond what would have occurred as a result of a typical stovetop fire. Going back to our earlier discussion, this is also going to involve a second set of experts. Your initial fire investigator is going to explain how and where the fire originated, that it's a stovetop fire. Now you need an expert in the field of fire suppression systems, and specifically the inspection and maintenance of fire suppression systems to evaluate why the suppression system didn't activate. In this scenario, it's been determined that the actuator wasn't reinstalled. So you have the pieces needed to put together a spread theory against the inspection company for creating this defect that prevented the suppression system from doing its job, that is, early extinguishment and containment of the fire. And that fact scenario can also get a little bit more complicated because part of your proofs is also going to be establishing that had the actuator been reinstalled, that the suppression system would have extinguished the fire. So there you need to make sure that as designed, the suppression system was code compliant and would have functioned as intended to extinguish the fire. So it's a layered approach. It's a much more complicated approach to a fire and to recovery, but it gives you that second bite at the apple where under the hypothetical where your insured is responsible for the initial event, there's responsibility that goes beyond that initial event for the inspection company, and you're able to both articulate the secondary cause and the damages attributed to that secondary cause.
You're right. That was a lot to unpack, but I think it was very helpful to walk through that analysis for purposes of figuring out what or how to pursue a spread theory. I think that's all the time that we have for today. And as you can tell, determining whether to pursue a spread theory requires a specific set of facts and considerations in the investigation phase of your case. I think it's essential to consider this option to ensure all avenues of recovery are explored. Ron, I want to thank you for discussing this with us today.
It's been my pleasure, Ryan. Thank you for walking me down a bit of memory lane on this one. Thank you for listening to this episode of Subro Sessions. You can find past episodes of the podcast on the White and Williams homepage, whiteandwilliams.com. Hover over the Insights link and select podcasts to find past episodes.
We would like to remind everyone that the contents of this podcast are intended for general informational purposes only, and you are urged to consult a lawyer concerning your own situation with respect to any specific legal question you may have. The podcast should not be construed as legal advice for a particular situation or to give a legal opinion on any specific facts or circumstances. Prior results do not guarantee a similar outcome.